I never imagined that the smell of cattle manure would land me in the middle of a legal war. But here I was, sitting in my truck, staring at a bright pink violation notice taped to my mailbox. The letter informed me that I had exactly 7 days to eliminate all offensive agricultural odors emanating from my property, or face daily fines of $500. My name is Isaac Harrison, and my family has been ranching this land in Montrose County, Colorado, since 1943. The McMansions surrounding my 200 acres. Those showed up in 1983. I pulled the notice down and climbed back into my truck, reading through the complaint as my border collie, Duke, panted in the passenger seat. The letter came from someone named Patricia Henderson, president of the Meadowbrook Estates Homeowners Association. She had listed a series of grievances: the smell of livestock, the noise of cattle early in the morning, the presence of unsightly farm equipment visible from neighboring properties, and dust from my gravel road drifting into the subdivision. Each complaint was typed in bold red font, as if the emphasis would make her demands more legitimate. The irony was thick enough to cut with a knife. My grandfather had purchased this land when it was nothing but high desert scrub and cottonwood trees along the creek. He had built the original ranch house with his own hands, raised cattle through droughts and blizzards, and passed the operation down to my father in 1971. I had inherited it in 2019 when Dad retired to Arizona for his health. The Harrison Ranch had been here long before anyone dreamed of building a gated community with its prissy rules and manicured lawns. I drove up the long gravel drive to my house, dust billowing behind me just like it had for 8 decades. My property sat on a gentle rise with views of the San Juan Mountains to the south. The original ranch house still stood, though I had added modern updates over the years. New roof, better insulation, solar panels on the barn. 140 head of black Angus cattle grazed in the pastures that stretched east toward the creek. 3 horses occupied the smaller paddock near the barn. This was a working ranch, not some hobby farm. My phone rang as I parked. It was my neighbor, Gerald Martinez, who lived in one of the older homes on the edge of the subdivision, a place built back when the development first went up. "Isaac, did you get one of those crazy letters?" Gerald asked without preamble. "You mean the pink monstrosity demanding I make my cattle stop smelling like cattle?" "Yeah, got it. Patricia is on a rampage. She moved here 6 months ago from Denver and apparently thinks she can turn Montrose County into Cherry Creek. She has been sending violation notices to everyone. I got cited because my fence is 4 inches too tall according to some rule buried in the HOA bylaws. 4 inches. My ranch predates her subdivision by 4 decades, Gerald. She has no authority here. Try telling her that. She is convinced the entire world needs to follow her rules. I would lawyer up if I were you. She is not backing down from anyone." I thanked Gerald and ended the call, my jaw tight with frustration. The cattle business was tough enough without some transplant from the city trying to regulate my livelihood out of existence. I had bills to pay, animals to care for, and a legacy to maintain. Patricia Henderson was about to learn that ranchers do not fold easily. The next morning, I drove into town to visit my lawyer, Martin Reeves, whose office occupied a converted Victorian house on Main Street. Martin had handled my father's estate and knew the ranch's history better than most. "Isaac, good to see you," Martin said, gesturing me into his office. He was in his early 60s, silver-haired, with the weathered look of someone who had spent plenty of time outdoors before turning to law. "What brings you in?" I handed him the pink notice. He read it slowly, his expression shifting from curious to amused to outright incredulous. She wants you to eliminate agricultural odors, he said flatly, from a cattle ranch. That is correct. And she is threatening $500 daily fines. Also correct. Martin set the letter down and leaned back in his chair. Isaac, I am going to need you to pull together every piece of documentation you have about your property. Deeds, surveys, tax records, everything. We need to establish beyond any doubt that your ranch predates this HOA and that you never agreed to be part of their association. My grandfather bought this land in 1943. The subdivision did not even break ground until 1983. I have all the paperwork at home in Dad's old filing cabinets. Good. Bring it all to me. In the meantime, do not respond to Patricia Henderson directly. Let me handle all communication. HOA disputes can get ugly fast, and anything you say to her could be twisted later. I spent that afternoon digging through decades of paperwork in my father's study. The original deed, signed by my grandfather and the previous landowner, showed the purchase of 200 acres for the sum of $8,000. There were surveys from various decades showing property lines that had never changed. Tax records stretched back continuously to 1943. Building permits for the barn in 1955, for the equipment shed in 1968, for the renovations to the main house in 1989. Every document confirmed what I already knew. The Harrison Ranch was established long before Meadowbrook Estates was even imagined. I also found something interesting buried in a folder labeled Legal Correspondence, 1983. It was a letter from a development company called Western Horizon Properties, requesting that my father sell a portion of his land to accommodate the new subdivision. My father had declined, but the letter included a proposed site map showing how the development would be positioned around the existing ranch. The developers had known full well that they were building next to an active cattle operation. I loaded everything into a box and drove back to Martin's office the next morning. He spent an hour reviewing the documents, occasionally making notes or scanning pages into his computer. "This is excellent," he finally said. "Your property rights are ironclad." The ranch was established 40 years before the HOA existed. You never signed any agreement to join the association, and your land is clearly exempt from their rules. More importantly, this letter from 1983 shows that the developers deliberately chose to build next to a working ranch. Any buyers in that subdivision were purchasing homes with full knowledge that agricultural operations were next door. So, what is our next move? I will send Patricia Henderson a formal response explaining that you are not subject to HOA jurisdiction and that any attempt to fine you will result in legal action. I will also include a brief history of your property to make it crystal clear that she has no leg to stand on. Do you think she will back off? Martin smiled grimly. People like Patricia do not back off easily. They are true believers. But once she realizes she could be on the hook for legal fees and potential damages if she keeps pushing, she might reconsider. 3 days later, I got my answer. Patricia Henderson showed up at my ranch in person. I was in the barn repairing a fence panel when I heard a car coming up the drive. I walked outside to see a white Mercedes SUV parking near my house. A woman in her late 40s stepped out, wearing cream-colored slacks and a blazer despite the warm May weather. Her blonde hair was styled in that particular way that required both money and considerable effort to maintain. She carried a leather portfolio under one arm. "Mr. Harrison." She called out, her voice sharp. "That would be me," I said, wiping my hands on my jeans. "I am Patricia Henderson, president of the Meadowbrook Estates HOA. I am here to discuss your violation notice. My lawyer told me not to communicate with you directly." If you have something to say, you can send it to Martin Reeves." Her expression tightened. "Mr. Harrison, I do not think you understand the seriousness of this situation. Your property is creating a nuisance for the entire community. The smell alone is driving down property values. I have received complaints from dozens of residents. Mrs. Henderson, I do not think you understand the situation. My family has been ranching this land since 1943. Your subdivision was built around my property in 1983. I am not part of your HOA, never agreed to be part of your HOA, and your rules do not apply to me. That is absurd. Everyone in this area is part of Meadowbrook Estates. Not everyone. Just the people who bought homes in your subdivision and signed your covenants. I did not buy a home there, and I sure as hell did not sign anything." Patricia opened her portfolio and pulled out a document. "According to our records, all properties within a 1-mile radius of the subdivision are subject to our community standards. That includes your ranch." I almost laughed. "That is not how property law works. You cannot just declare that you have authority over land you do not own. Where did you even get that idea? It is in our master deed. Your master deed only applies to properties that are part of your development. My ranch is not part of your development. It predates your development by 40 years. Her face was turning pink now, a flush creeping up her neck. "Mr. Harrison, I am trying to be reasonable here, but if you refuse to comply with our community standards, I will have no choice but to escalate this matter. The fines will continue to accumulate, and we will pursue legal action to collect them. You do that, and when my lawyer is done with you, your HOA will be paying my legal fees plus damages for harassment. Now get off my property." Patricia stared at me for a long moment, her jaw working like she was chewing through her words before spitting them out. "You are making a serious mistake, Mr. Harrison. Nobody fights the HOA and wins. Watch me." She spun on her heel and marched back to her Mercedes. Gravel sprayed as she peeled out of my driveway. Duke, who had been watching from the barn, trotted over and sat next to me. "Well, boy, I think we just made an enemy," I said, scratching behind his ears. "That evening, Martin called. I heard Patricia came to your ranch today. What happened?" I recounted the conversation. Martin listened without interrupting. "She is bluffing about the master deed," he said when I finished. "I reviewed the subdivision's founding documents this afternoon. There is no clause that extends HOA authority to pre-existing properties outside the development. She either made that up or misunderstood something she read. So what happens now? Now we wait. I sent my response letter this morning via certified mail. She should receive it tomorrow. Once she consults with the HOA's attorney, assuming they have one, they will realize they have no case. The problem is that Patricia strikes me as the type who will not let go even when she is clearly wrong. Pride gets in the way of sense." Martin was right. 2 days later, I received another notice, this one claiming that I owed $1,500 in accumulated fines for failure to comply with the initial violation. The letter warned that if payment was not received within 5 business days, the HOA would place a lien on my property. I photographed the letter and sent it to Martin. He called back within the hour, his voice tight with barely controlled anger. "They are threatening to lien your property. Isaac, this has crossed from annoying into actionable. I am going to file for an injunction to stop them from pursuing any collection action. And I am also going to send a cease and desist letter threatening a lawsuit for harassment and abuse of process. This needs to end now before they do something even more stupid. Can they actually put a lien on my ranch? They can try, but it would not be valid. The problem is that even an invalid lien can cause you headaches. It could affect your credit, complicate any financing you might need, create title issues if you ever want to sell. It is a mess to clean up even when you are completely in the right. So they are basically trying to bully me into paying money I do not owe to make them go away. Exactly, and that is illegal. HOAs have certain powers when it comes to enforcing legitimate rules against members who agreed to those rules, but they do not have the power to extort non-members, which is essentially what Patricia is doing. Martin filed the paperwork that week. On a Monday morning in early June, I had to drive to the Montrose County Courthouse for a hearing on the injunction. The courtroom was small, wood-paneled, with rows of benches that reminded me of church pews. Martin sat next to me at the plaintiff's table. Across the aisle, Patricia Henderson sat with a lawyer I did not recognize, a younger man in an expensive suit who looked uncomfortable. Judge Sarah Brennan, a no-nonsense woman in her 50s, reviewed the case file before looking up at both parties. This is a petition for injunctive relief to prevent the Meadowbrook Estates, HOA, from pursuing collection action or placing liens against Mr. Harrison's property. Mr. Reeves, you represent the petitioner. Yes, Your Honor, Martin said, standing. My client owns and operates a cattle ranch that has been in his family since 1943. The Meadowbrook Estates subdivision was built adjacent to his property beginning in 1983. Mr. Harrison has never been a member of the HOA, never signed any agreement to be bound by their rules, and his property is not part of their development. Despite this, the HOA has issued violation notices, demanded payment of fines, and threatened to lien his property for supposed violations of HOA rules that do not apply to him. Judge Brennan turned to the HOA's attorney. Mr. Chen, what is your response? The lawyer, Chen, stood slowly. Your Honor, the HOA maintains that all properties within the designated community area are subject to certain minimum standards designed to preserve property values and quality of life for residents. Mr. Harrison's cattle operation creates odors and noise that negatively impact the community. That does not answer my question, Mr. Chen. Is Mr. Harrison's property part of the Meadowbrook Estates subdivision? Not technically, Your Honor, but is his property subject to the HOA's covenants, conditions, and restrictions? Chen hesitated. The HOA believes that certain nuisance standards should apply universally. Belief is not law, Mr. Chen. Did Mr. Harrison or any of his predecessors sign an agreement to be bound by the HOA's rules? No, Your Honor. Then on what legal basis does your client claim the authority to fine him or lien his property? Chen looked at Patricia, who was practically vibrating with indignation in her seat. Your Honor, we believe that agricultural operations in close proximity to a residential subdivision constitute a nuisance under Colorado law, and that the HOA has standing to pursue abatement of that nuisance. Judge Brennan leaned back in her chair. Mr. Chen, are you aware that Colorado is a right-to-farm state? Yes, Your Honor, and are you aware that Mr. Harrison's ranch predates the subdivision by approximately 40 years? Yes, Your Honor. Then you should also be aware that Colorado's right-to-farm laws specifically protect agricultural operations from nuisance claims when those operations existed before nearby development. The people who bought homes in Meadowbrook Estates chose to purchase property next to a working cattle ranch. They came to the nuisance, not the other way around. Your client has no standing to pursue any action against Mr. Harrison based on normal ranching activities. Patricia stood up suddenly. Your Honor, this is ridiculous. We have rights too. We should not have to smell cow manure every time we walk outside. Judge Brennan's expression went cold. Mrs. Henderson, you will sit down and remain silent unless I ask you a question. Your attorney speaks for you in this courtroom. Patricia sat, her face flushed dark red. Chen looked like he wanted to be anywhere else. "I am granting the injunction," Judge Brennan said. "The Meadowbrook Estates, HOA, is hereby prohibited from pursuing any collection action against Mr. Harrison, from placing any liens against his property, and from issuing any further violation notices based on normal agricultural operations. Furthermore, I am ordering the HOA to rescind all existing fines. Mr. Chen, I suggest you advise your client that any further harassment of Mr. Harrison could result in sanctions. Do I make myself clear?" "Yes, Your Honor." "Good. We are adjourned." I felt the tension drain from my shoulders as Martin and I walked out of the courthouse. Patricia and her lawyer were ahead of us, her voice carrying back as she berated Chen for his failure to argue more forcefully. "That went well," Martin said with satisfaction. "The judge basically gave us everything we asked for. You think this is over, with a reasonable person?" "Yes, with Patricia Henderson, I am not optimistic." His skepticism proved warranted. 3 weeks later, I was driving back from town when I noticed a county vehicle parked at my gate. A man in a polo shirt with Montrose County Environmental Health embroidered on it was taking photographs of my property. I pulled up next to him and rolled down my window. "Can I help you? Are you the property owner?" he asked. "Isaac Harrison. I own the ranch. What is this about?" "We received a complaint about potential violations of county health codes. Improper waste management, water contamination, that sort of thing. I am here to conduct an inspection." "Who filed the complaint?" He consulted his clipboard. "It was submitted anonymously." "Of course it was." "Do you have a warrant to be on my property?" "I do not need a warrant for an exterior inspection, but I would need your permission to access buildings or inspect operations up close." "Let me call my lawyer." I phoned Martin, explained the situation, and handed the phone to the inspector. They talked for a few minutes before the inspector gave me back my phone. "Your lawyer says I can conduct the exterior inspection, but that you are not granting access to buildings without a warrant," the inspector said. "That is within your rights, but it will make this take longer." "Then it takes longer." I followed him around the perimeter of my property, watching as he photographed the cattle, the barn, the manure management area, and the creek that ran through the eastern section. He took water samples from the creek and tested them with a handheld device. After about an hour, he finished and approached me where I waited by the fence. "Everything looks fine from what I can see," he said. "Your waste management setup is actually better than most ranches I have inspected. The creek water is clean. I do not see any violations. So we are done. I will file my report. If the complainant wants to pursue it further, they will need to provide more specific allegations." He drove away, leaving me standing in my driveway, furious. Patricia was trying to weaponize county agencies against me now that the direct approach had failed. It was clever in a petty, vindictive way. Even if the inspections found nothing wrong, they cost me time and stress. Over the next 2 months, I received visits from 3 more county officials. A second environmental health inspector responding to a different, anonymous complaint, a building code inspector checking for unpermitted structures, and an animal control officer investigating allegations of livestock abuse. Every single inspection found nothing wrong. Every single complaint had been anonymous, and every single one cost me hours of my day dealing with bureaucrats who were just doing their jobs. Martin advised me to start documenting everything. I kept a log of each inspection, including dates, times, who conducted it, and what they found. I also installed security cameras around my property after I noticed that someone had driven onto my land late one night, leaving tire tracks near the barn but nothing obviously damaged or stolen. In August, things escalated further. I was feeding the horses one morning when Gerald called. "Isaac, I am at the HOA meeting right now. You need to hear this. Patricia just proposed that Meadowbrook Estates attempt to purchase your ranch through eminent domain." "What? They cannot do that. HOAs do not have eminent domain authority." "She is talking about getting the county involved. She wants to argue that your ranch is blighted property that is negatively impacting the community and that taking it for redevelopment would serve the public good." My blood went cold. That is insane. This is a working ranch, not blighted property. I know that, and most of the people here know that, but Patricia is very persuasive. She has a whole presentation about increased tax revenue if your land was converted to residential development. Some of the newer residents are eating it up. What can I do? Get to the next county commissioner meeting and make sure they know what is going on. If Patricia manages to get an eminent domain proceeding started, it will cost you a fortune to fight even if you ultimately win. I spent the next week preparing. Martin helped me put together a presentation showing the ranch's history, its economic contribution to the county, and the legal protections afforded to agricultural operations under Colorado law. I reached out to other ranchers in the area, many of whom agreed to attend the commissioner meeting in a show of support. The Montrose County Commissioner meeting was held on a Tuesday evening in late August. The meeting room was packed. On one side sat Patricia and about 20 residents from Meadowbrook Estates, many of whom I had never seen before. On the other side sat me, Martin, Gerald, and at least 30 ranchers and farmers from around the county, many wearing their work clothes, smelling of hay and earth and livestock. Patricia presented first. She had polished slides showing property values in neighborhoods near agricultural operations versus purely residential areas. She cited noise complaints, odor complaints, and dust complaints. She argued that converting my ranch to residential development would generate significant tax revenue and create a better quality of life for hundreds of families. Then it was my turn. I stood at the podium, acutely aware of every eye in the room on me. My name is Isaac Harrison, and my family has been ranching in Montrose County since 1943. My grandfather bought 200 acres of high desert land when this area was nothing but scrub and hope. He built a life here, raised a family here, and created a legacy that has lasted 3 generations. My father continued that legacy, and I am continuing it now. I am not here to argue about property values or tax revenue. I am here to talk about what we are as a community. Montrose County has always been agricultural country. That is our heritage. That is our culture. When developers come in and build subdivisions next to existing farms and ranches, they are not doing us a favor. They are betting that people will want to live near open space and mountain views and a little taste of rural life. But then some of those people decide they want all the benefits of rural living without any of the realities. They want the views without the smells. They want the open space without the dust. They want the Western lifestyle without the work. My ranch predates Meadowbrook Estates by 40 years. The developers who built that subdivision knew exactly what they were doing when they positioned it next to my property. They disclosed it to buyers, or they should have. Anyone who purchased a home there did so with full knowledge that they were moving next to a cattle operation. Now some of those buyers want to use government power to erase something that was here long before they were, and that is wrong. Colorado is a right to farm state for a reason. We protect agriculture because it matters. It feeds people. It preserves open space. It maintains a way of life that built this state. If we start using eminent domain to seize working ranches because they inconvenience suburban homeowners, We are telling every farmer and rancher in Colorado that their property rights mean nothing. We are saying that their livelihoods can be erased whenever a vocal minority decides they are a nuisance. I am asking you as county commissioners to reject this proposal completely. My ranch is not blighted. It is not a nuisance. It is a productive agricultural operation with decades of history and a future worth protecting. Thank you. I sat down. The ranchers on my side of the room clapped. Patricia's face was tight with anger. The commissioners deliberated for about 15 minutes before the chairman, Commissioner David Walsh, spoke. The board has reviewed the request and heard testimony from both sides. We find no basis for pursuing eminent domain action against the Harrison Ranch. The property is not blighted. It serves a legitimate agricultural purpose, and it enjoys specific protections under Colorado law. Furthermore, the Colorado Constitution requires that eminent domain serve a public use, and converting productive ranch land into another subdivision does not meet that threshold. This request is denied. The relief hit me like a physical wave. Martin clapped me on the shoulder. Around us, the ranchers were nodding and murmuring approval. On the other side of the room, Patricia was already gathering her things, her movements sharp and angry. I thought that might finally be the end of it. I was wrong. In late September, I woke one morning to discover that someone had cut my fence during the night. 3 sections of barbed wire were down, and about 40 head of cattle had wandered onto the county road. I spent 4 hours with Gerald and 2 hired hands rounding them up and repairing the fence. Fortunately, no cattle were hit by cars, but it was a close thing. I filed a police report. Deputy Tom Wilson came out to take photos and statements. "Any idea who might have done this?" he asked. "I have an idea, but no proof." The HOA. Patricia Henderson has been making my life hell for months, but like I said, no proof. I will keep an eye on the area at night. If we catch someone messing with your property, we will throw the book at them. A week later, it happened again. Different section of fence, same result. This time, I had the security camera footage. The video showed a truck approaching around 2 in the morning, 2 figures climbing out and cutting the wire, then driving away. The license plate was not visible, and the faces were obscured by dark clothing and caps, but the truck looked like one I had seen parked at Patricia Henderson's house. Deputy Wilson reviewed the footage. This is definitely criminal mischief, possibly agricultural terrorism, depending on how the DA wants to charge it. But without a clear identification, it is hard to make an arrest. What if I could prove whose truck that is? If you can prove it belongs to someone involved with the HOA, that would be a start. But we need more than just a similar-looking vehicle. I spent the next several nights staking out my own property, parked in a hidden spot with a clear view of the fences along the road. On the 4th night, around 3 in the morning, I saw headlights approaching slowly. I grabbed my phone and started recording as a dark blue Ford pickup pulled up near the fence. 2 men got out, both wearing dark clothes. One of them pulled out wire cutters. I called 911 while still recording. "This is Isaac Harrison at 4850 County Road 12. I have intruders on my property actively cutting my fence. I need sheriff's deputies right now." The dispatcher kept me on the line. I kept recording. The men cut through 2 sections of wire before they heard sirens in the distance. They ran back to the truck and peeled out, but not before my camera caught a clear shot of the license plate. 2 sheriff's vehicles arrived within minutes. I showed them the footage and gave them the license plate number. Deputy Wilson ran it immediately. "The truck is registered to Mark Henderson," he said. "Any relation to Patricia Henderson? I would bet money he is her husband. We will bring him in for questioning." This footage gives us probable cause. Within 2 days, Mark Henderson was arrested and charged with criminal mischief and agricultural terrorism, a felony in Colorado when it involves damage to working farms or ranches. The second man in the video was identified as Richard Sutton, a board member of the Meadowbrook Estates HOA. He was also arrested and charged. Both men initially refused to talk, but Richard eventually cut a deal. In exchange for a reduced sentence, he testified that Patricia Henderson had hired them to harass me into selling the ranch. She had paid them $2,000 per incident to cut fences, hoping that the stress and cost of constant repairs would break me down. She had also been the source of all the anonymous complaints to county agencies, a fact she had admitted to Richard during one of their meetings. The district attorney, Melissa Ramirez, was not amused. Patricia Henderson was arrested in early October and charged with conspiracy to commit criminal mischief, solicitation to commit a felony, making false reports to government agencies, and harassment. The charges carried potential prison time. The preliminary hearing was held in mid-November. I attended, sitting in the back of the courtroom with Martin. Patricia arrived with a high-priced criminal defense attorney from Grand Junction, a sharp woman named Angela Foster who had a reputation for aggressive tactics. The prosecution laid out its case methodically. They presented the video footage, Richard Sutton's testimony, phone records showing repeated calls between Patricia and both men in the days before each fence-cutting incident, and bank records showing cash withdrawals matching the amounts Richard testified she had paid them. They also presented evidence of Patricia's campaign to use county agencies to harass me, including emails she had sent to other HOA members bragging about how she was making the rancher's life miserable. Angela Foster tried to poke holes in Richard's credibility, arguing that he was lying to save himself. But the documentary evidence was overwhelming. The phone records, the bank records, and Patricia's own emails painted a clear picture of a calculated campaign of harassment and property damage. Judge Brennan, the same judge who had granted my injunction months earlier, listened to everything with an increasingly stern expression. "Mrs. Henderson," she said when the testimony concluded, "you are charged with serious crimes motivated by nothing more than personal spite. You attempted to drive Mr. Harrison from property his family has owned for over 80 years, using illegal means including property damage, conspiracy, and abuse of governmental processes. The evidence against you is substantial. I am binding you over for trial and setting bail at $50,000. Patricia's face went white. Her attorney argued for lower bail, but Judge Brennan was unmoved. The trial took place in January 2026. I testified about the months of harassment, the violation notices, the threats, the inspections, and finally the fence-cutting incidents. Martin testified about the HOA's legal overreach. Deputy Wilson and other sheriff's personnel testified about the investigation. Richard Sutton repeated his earlier testimony, looking miserable as he described how Patricia had recruited him and Mark. The prosecution also called several residents from Meadowbrook Estates, who testified that Patricia had become increasingly obsessed with the ranch, talking about it constantly at HOA meetings, and insisting that removing me was essential to improving the neighborhood. One woman, a retired school teacher named Barbara Ross, testified that Patricia had suggested breaking into my house to plant evidence of code violations, an idea that had shocked several board members. The defense tried to argue that Patricia had been acting in what she believed were the best interests of the community, that she had never intended serious harm, and that the conspiracy case was overblown. But the jury was not sympathetic. After 3 days of testimony and less than 4 hours of deliberation, they returned guilty verdicts on all counts. At sentencing in February, Judge Brennan was blunt. "Mrs. Henderson, you waged a campaign of harassment and criminal activity against a man whose only offense was owning property you coveted. You abused your position as HOA president to make his life difficult, and when legal methods failed, you turned to crime. You hired people to damage his property and endanger his livestock, all while lying to government agencies to create additional pressure. Your actions were calculated, sustained, and malicious. I am sentencing you to 3 years in the Colorado Department of Corrections, followed by 3 years of probation. You are also ordered to pay full restitution to Mr. Harrison for all costs he incurred as a result of your actions, including legal fees, fence repairs, and time lost dealing with your harassment. Additionally, you are prohibited from holding any position of authority in a homeowners association for 10 years following your release." Patricia began crying. Her attorney filed notice of appeal, but the sentence stood. Mark Henderson and Richard Sutton both received lighter sentences as part of their plea agreements. 1 year in county jail and 5 years probation each, plus restitution. The Meadowbrook Estates HOA issued a public apology to me in March, along with a formal acknowledgement that my ranch was not subject to their jurisdiction, and a promise not to pursue any further action. The board had removed Patricia from her position as president immediately after her arrest, and the new leadership wanted to distance themselves from her actions. Several residents reached out personally to apologize, including Barbara Ross, who brought me a homemade pie and expressed her horror at what Patricia had done. "Most of us moved here because we liked being near open space," Barbara said as we sat on my porch. "We knew there was a ranch next door." That was part of the appeal. Patricia was an aberration, thank God. Gerald stopped by frequently throughout the ordeal, offering support and occasionally helping with ranch work when I was too tied up with legal matters to keep up. "I told you she was on a rampage," he said one afternoon as we mended fence together. "But I never thought it would go this far." Neither did I. I figured she would give up once the judge slapped her down. Some people cannot let go. They would rather destroy themselves than admit they are wrong. By spring 2026, life had returned to something approaching normal. The cattle grazed peacefully in the pastures. The horses dozed in the sun. Duke chased rabbits through the sage. The mountains stood purple and white against the blue sky, the same view my grandfather had seen when he first bought this land. The restitution payments from Patricia, Mark, and Richard more than covered my legal costs and repairs, with enough left over to finally replace the aging roof on the barn. Martin had also helped me file a civil lawsuit against the HOA for the harassment campaign, which settled out of court for an undisclosed sum that gave me some financial breathing room. I was in town one Saturday in April when I ran into Angela Foster, Patricia's defense attorney at the hardware store. "Mr. Harrison," she said, nodding politely, "Miss Foster. For what it is worth, I am glad things worked out for you. What Patricia did was indefensible. I took her case because everyone deserves a defense, but I will not pretend she was in the right. I appreciate that. No hard feelings. You are more gracious than most people would be." I thought about that on the drive home. I was not particularly gracious. I was just tired. The whole ordeal had consumed nearly a year of my life, cost me thousands of dollars even with the restitution, and added stress I did not need. But it had also reminded me why this land mattered, why the work mattered, and why some things were worth fighting for. My phone rang as I pulled into my driveway. It was my father calling from Arizona. "I heard the sentencing went through," he said. "How are you holding up?" "I am all right, Dad. Tired, but all right. Your grandfather would be proud of you, standing up for the ranch like you did." "I just did what needed doing." "That is what ranching is, son. Doing what needs doing day after day, whether it is easy or not. You proved you have what it takes to hold onto this place." After we hung up, I stood in the driveway for a while, looking out over the land. The afternoon sun cast long shadows across the pastures. The cattle were dark shapes moving slowly through the grass. Somewhere in the distance, a hawk cried out. This was my legacy. Not just the land itself, but the choice to defend it, to refuse to be pushed out by people who thought rules and money could override history and sweat and time. The Meadowbrook Estates subdivision sat to the west, rows of houses with their neat lawns and two-car garages. Most of the people who lived there were good folks just trying to make a life for themselves, same as me. They were not the problem. The problem had been one person who could not accept that not everything bends to her will, who saw an obstacle and decided the solution was to break the law. In May, I got a letter from the Colorado Cattlemen's Association. They had heard about my case and wanted to feature it in their newsletter as an example of successful defense of agricultural property rights. I agreed, and the article ran in the June issue. I got calls and emails from ranchers across the state, many of them sharing their own stories of conflicts with development, HOA, or neighbors who had moved to the country, and then complained about country life. One rancher in Weld County told me about a similar situation where an HOA had tried to ban his irrigation system because the sprinklers made noise at night. Another in La Plata County described a neighbor who had sued over the sound of roosters crowing in the morning, despite the fact that the chicken operation had existed for 30 years before the neighbor bought his house. Each story reinforced what I had learned. The fight to preserve agricultural land and agricultural ways of life was constant, and it required vigilance. But there were victories, too. The right to farm laws existed for a reason, and when push came to shove, Colorado courts and Colorado juries understood the value of protecting ranches and farms. My case had set a clear precedent in Montrose County that HOAs could not harass or intimidate non-member property owners into submission, and that criminal tactics would be met with serious consequences. By summer, the whole ordeal had receded into memory, something I could talk about without feeling my jaw clench. The ranch hummed along with its usual rhythms: calving season, branding, pasture rotation, hay harvest, maintenance projects that never seemed to end. It was hard work, physical and demanding, but it was honest work. My body ached at the end of most days, but it was the good kind of ache that came from accomplishment. Gerald and I became better friends through the whole experience. He had stood by me when he did not have to, attending meetings and hearings, offering support and occasionally legal advice from his own experience fighting HOA overreach. We started getting together for dinner once a month, trading stories and complaints about property maintenance, county regulations, and the general absurdity of modern life. "Did you ever think about selling?" Gerald asked one evening as we sat on my porch, watching the sun set behind the mountains. "When things were at their worst, I mean." "Never seriously," I said. "This land is not just property to me, it is family history. It is where my grandfather fought through the Dust Bowl aftermath, and my father learned to ride, and I grew up understanding what it means to take care of something bigger than yourself. Patricia Henderson could not buy that, and she sure as hell could not take it. Good. We need more people like you. People who remember what this area was before it became a bedroom community for Grand Junction. The irony was that property values in Meadowbrook Estates had not declined despite Patricia's dire predictions. If anything, they had remained stable or even increased slightly, driven more by Colorado's general population growth than by proximity to my ranch. The apocalyptic scenario she had painted, where the smell of cattle would drive everyone away and turn the subdivision into a ghost town, had never materialized. People who chose to live in Montrose County, generally, understood that agriculture was part of the landscape. In August, the new HOA president, a retired engineer named Thomas Wright, stopped by the ranch to introduce himself properly and extend another apology on behalf of the community. "We have implemented new rules," Thomas explained as we walked around the property. "Any complaints about neighboring properties that are not part of the HOA have to be vetted by our attorney before any action is taken. We also added a requirement that all board members complete training on property law and HOA authority. What happened with Patricia cannot happen again." "I appreciate that, Thomas. Most of your residents have been fine. It was just one bad apple, a very bad apple, unfortunately. She did a lot of damage to the HOA's reputation in the community. We are working to rebuild trust." "Well, you are off to a good start." As fall approached, I prepared for the annual cattle sale. This year's calves had come in strong and healthy, and prices were good. The operation was finally profitable again after a couple of lean years. I hired a couple of local kids to help with the roundup and sorting, teaching them the same skills my father had taught me decades earlier. One of them, a high school senior named Jake, asked me about the HOA situation during a break. "My mom talks about it sometimes," he said. "She said you stood up to them and won." "I defended what was mine," I said, "but I had a lot of help. Good lawyer, good neighbors, good laws. Without those things it could have gone differently. Still, most people would have given up. Maybe. But most people do not have 80 years of family history sitting on the land they are being told to abandon. That changes things." Jake nodded thoughtfully. "I want a ranch someday. My parents think I should go to college and get a real job, but I like this better. You can do both. Get educated, learn about business and economics and agricultural science, then come back and apply it. Ranching is not just riding horses and roping cattle anymore. You need to understand markets, water law, genetics, nutrition, technology. The more you know, the better you can adapt." "Did you go to college?" "I did. Colorado State. Degree in agricultural business. My father insisted, and he was right. The education helped me run this place more efficiently and gave me options when times got tough." We finished the sorting and loaded the cattle for transport. The sale went well, bringing in enough revenue to cover expenses for the winter and leave some left over for equipment upgrades. It felt good, like the ranch was finally stabilized after the chaos of the previous year. In October, I attended the Montrose County Fair, something I had done every year since childhood. I entered some of my cattle in the competitions and spent time walking through the exhibits, talking with other ranchers, and eating decidedly unhealthy fair food. It was tradition, and after everything that had happened, I appreciated tradition more than ever. At the fair, I ran into Barbara Ross from the HOA. She was volunteering at the agricultural education tent, helping city kids understand where their food came from. "Isaac, how wonderful to see you," she said, giving me a warm hug. "Are you doing well?" "I am, Barbara. Things are finally settling down." "I am so glad. What Patricia put you through was unconscionable. I lost a lot of sleep over it. It was not your fault." "Maybe not directly, but I was on the board. I should have pushed back harder when she started talking about taking action against you. I let her dominate the conversation because it was easier than confronting her. That was cowardly. You testified at her trial. That took courage. It was the least I could do. We talked for a while longer, and I came away from the conversation feeling like the community was healing. The division that Patricia had tried to create between the ranch and the subdivision was closing. People were remembering that neighbors should support each other, not tear each other down. As winter approached, I settled into the quieter rhythm of off-season ranch work. There was equipment to repair, fences to check, hay to distribute, and livestock to monitor through the cold months. The mountains turned white with snow, and the temperature dropped below freezing most nights. It was harsh, beautiful country that demanded respect and gave back grudging rewards. On Christmas Eve, I invited Gerald and his family over for dinner. His wife made tamales, and I contributed a smoked brisket from one of my steers. We sat around my dining room table, laughing and telling stories, and for a few hours I felt completely content. This was what I had been fighting for. The ability to live my life on my own terms, to welcome friends into my home, to maintain the legacy my grandfather had built. After dinner, Gerald and I stood outside under the stars while his wife and kids cleaned up inside. "Hell of a year," Gerald said. "That it was. But you made it through. The ranch is still here. You are still here. Thanks in large part to you. I would not have known half of what Patricia was planning without your heads up from those HOA meetings. That is what neighbors do. We look out for each other." I looked out across the dark pastures, the snow reflecting starlight, the shapes of the mountains barely visible against the sky. Somewhere out there, the cattle were bedded down for the night, warm and safe. The ranch would still be here tomorrow and the day after that, and for as long as I had the strength to maintain it. Patricia Henderson was in prison, serving her sentence for crimes born of arrogance and spite. Mark Henderson and Richard Sutton had served their time and been released, both now probationers with criminal records that would follow them for life. The HOA had apologized and reformed its policies. The county had established clearer guidelines about agricultural protections. And I had learned that standing your ground when you are in the right could actually work. The story spread beyond Montrose County. I gave a couple of interviews to agricultural publications and even appeared on a podcast about property rights. Each time, I tried to emphasize that this was not about me being special or heroic. It was about ordinary people defending what mattered to them against those who thought power and money could override rights and history. By the spring of 2027, more than a year after Patricia's sentencing, life had truly returned to normal. The Meadowbrook Estates subdivision and the Harrison Ranch coexisted peacefully, two different worlds occupying the same landscape, mostly ignoring each other except for the occasional friendly wave. Property values in the subdivision continued to climb. My cattle continued to graze and grow and eventually head to market. I hired a ranch hand that spring, a young guy named Carlos who had grown up on a ranch in Texas and was looking for steady work in Colorado. He was a hard worker, good with cattle, and willing to learn. Having the extra help meant I could finally take a vacation, something I had not done in years. I spent a week in Arizona visiting my father, who was delighted to hear all the details of the ranch's operations and pleased that I had found good help. We spent afternoons sitting on his patio, drinking iced tea, and talking about cattle genetics, market trends, and family memories. He told me stories about my grandfather that I had never heard before, tales of stubborn determination and quiet strength that explained a lot about where I came from. "Your grandfather fought off a bank foreclosure in the 50s, Dad said one afternoon. Drought had hit hard, cattle prices were in the toilet, and the bank wanted to take the ranch. He went to every creditor personally, worked out payment plans, took a job in town for a year to make extra money and saved the place. He never talked about it much, said it was just what needed doing. I did not know that. There is a lot of history in that land that does not make it into the official records, struggles and victories that only the family knows about. What you did, standing up to that HOA, that is part of that history now. Someday you will tell your kids or grandkids about it, and it will be another layer in the story of the Harrison Ranch. I did not have kids yet, was not even dating anyone seriously, but the idea appealed to me. The thought that this land could continue beyond me, could carry forward into another generation, made all the hardship worthwhile. When I returned to Colorado, the ranch looked beautiful in the late spring sunshine. The grass was green from recent rains, the cattle were fat and healthy, and Carlos had kept everything running smoothly in my absence. I felt a surge of pride and gratitude, grateful for this place, these animals, this life that had been threatened but never broken. One evening in June, I was sitting on the porch when a car pulled up the driveway. I did not recognize it at first, but when the driver got out, I realized it was Thomas Wright, the HOA president. "Thomas, what brings you out here?" I called. "I wanted to give you something," he said, climbing the porch steps. He handed me an envelope. "Open it." Inside was a formal resolution from the Meadowbrook Estates HOA, signed by every board member and dozens of residents. It officially recognized the Harrison Ranch as a valued part of the community's heritage, acknowledged its historical and agricultural significance, and pledged ongoing support for its continued operation. At the bottom was a handwritten note from Barbara Ross. "Thank you for not giving up on us as neighbors. We are better for having you here." I felt a lump in my throat as I read it. "Thomas, this is really thoughtful, thank you. It was Barbara's idea, but we all supported it. After everything that happened, we wanted you to know that Patricia did not speak for the community. Most of us respect what you do here and would never want to see it go away." We talked for a while, and then Thomas left. I sat on the porch holding that resolution, reading it over and over. It was not legally binding, did not change any laws or establish any new protections, but it meant something anyway. It meant that people saw value in what I did, that they understood the ranch was not just an inconvenience but a piece of living history worth preserving. As summer rolled on, I found myself reflecting a lot on the journey. From that first ridiculous pink violation notice, to the courtroom battles, to the criminal trials, to this moment of peace and recognition, it had been exhausting and infuriating and ultimately affirming. I had learned things about myself, that I was tougher than I thought, that I could not be bullied into abandoning my principles, and that good people outnumbered bad ones even in difficult situations. The ranch continued its cycles, seasons turning into each other in the eternal pattern of agricultural life. Calving, branding, pasture rotation, haying, selling, starting over. It was repetitive in the best way, a rhythm that connected me to my grandfather and father, and all the ranchers who had worked this land before we ever set foot on it. In September, I got a letter from the Colorado State University Agricultural Extension Office. They wanted to use my case in their educational materials for ranchers dealing with conflicts with residential development. I agreed, hoping that maybe my experience could help someone else navigate similar waters. The letter reminded me of something Martin had said during the early days of the fight. Most HOA disputes do not make it to court because people give up. They either cannot afford the legal costs or just do not have the energy to fight. The HOAs know this and count on it. When someone actually stands up to them, especially with solid legal ground, they usually fold. I had been lucky. Lucky to have the documentation proving my property rights, lucky to have a good lawyer, lucky to live in a state with strong agricultural protections. Lucky that Patricia's criminal behavior had been so egregious that it resulted in consequences. Not everyone in my situation would have those advantages, but I had also been persistent. I had not given up when the pressure mounted. I had trusted the legal system, even when it felt slow and frustrating. I had kept fighting because the alternative, abandoning land my family had held for 80 years, was unthinkable. As I write this in October 2027, almost 2 years after Patricia Henderson's arrest, the Harrison Ranch is thriving. Cattle prices are strong. The operation is profitable. My relationship with the Meadowbrook Estates subdivision is cordial or better. I have even made friends with a few residents who stop by occasionally to see the cattle or buy grass-fed beef directly from me. The legal precedent set by my case has already been cited in 2 other HOA disputes in Colorado, both times successfully defending agricultural operations from overreaching associations. Martin tells me that HOA attorneys across the state are being more careful now about asserting authority over non-member properties, which benefits not just ranchers but anyone living near an HOA without being part of one. Patricia Henderson served 18 months of her 3-year sentence before being released on parole for good behavior. I heard she moved to New Mexico after her release, trying to start over somewhere nobody knew her story. I do not wish her ill, but I do not particularly care what happens to her either. She made her choices, faced the consequences, and now lives with them. Mark Henderson and Richard Sutton both completed their sentences and probation. Mark and Patricia divorced during her incarceration. Richard stepped down from all HOA involvement and largely disappeared from community life. The ripples of their crime spread far beyond the legal system, destroying relationships and reputations in ways that prison time could never fully address. For me, life goes on. The sun rises over the mountains each morning. The cattle need feeding. The fences need mending. The work never stops, but I would not want it to. This land demands something of me, and in return it gives me purpose, identity, and connection to something larger than myself. I think about my grandfather sometimes, wonder what he would make of all this. He lived in a simpler time in some ways, when property rights were clearer, and neighbors did not try to regulate each other into submission. But he also lived through the Depression, world wars, and droughts that would break most people today. He would probably tell me that every generation has its battles, and the important thing is showing up to fight them. So that is what I do. I show up every day. I take care of the cattle. I maintain the land. I defend what is mine when necessary. I welcome friends and neighbors. I honor the past while building the future. And I remember that a ranch is not just land and animals. It is history, legacy, and a promise to those who come after. The smell of cattle still drifts across the pastures on warm afternoons. The dust still rises from the gravel drive when trucks pass. The sounds of livestock still fill the air at dawn. And every bit of it is exactly as it should be, exactly as it has been for 84 years, a piece of the American West that endures because someone chose to fight for it. That someone was me, and I would make the same choice again.